Yes. So I've got to bring up another PowerPoint presentation, which I'll share on the screen. But in the meantime, I'll just introduce the team. So to my right is Russell Fernandez. Introduce yourself.
So I'm Russell Fernandez, the maintenance engineer manager at Top Energy. So worked a fair bit around the country. Done a bit of time in Taranaki, Auckland, and now North. Essentially, just look after the community and keep the lights on.
We also have online Mr. John Stiles. So John, if you could turn your camera on, just introduce yourself to the panel.
Good morning.
Good morning,
So
Mr.
I'm John Stiles, and I've been advising Top Energy on acoustic matters.
Good morning, Mr. Style.
Then we also, I do have a colleague, Moana Chauffeur, online as well from Barker & Associates. Moana, can you just turn your camera on and briefly introduce yourself? Oh, you're on mute.
Sorry about that. Morning, everyone. So I am Moana Chauffeur, and I'm a senior planner at Barker & Associates, and I've been assisting David with the proposed final district plan reviews for a number of clients, including Top Energy.
Thank you very much and good morning.
Thank you. And then finally, we have another John with an H. John Williams from Top Energy is also online. John, if you could introduce yourself, please.
Yes, I'm John Williams. I'm a network planning engineer specialising in protection and control systems for Top Energy.
Good morning, Mr. Williams.
Okay,
Good morning.
Share up presentation again. But we'll go in this order. So again, I've pulled together a PowerPoint presentation on Top Energy's evidence, which I'll run through. Again, I'll send a copy to AK to circulate around after this as well.
So to set the scene, again, Top Energy is not against the noise provisions or the earth provisions in total. It's just a few tweaks.
Absolutely. Thank you, Chair. Yes, there are a number of isolated areas in contention, which I will talk to. The first two of those are relating to the noise chapter. Unfortunately, I was a little bit late this morning dropping off my daughter at school on the way up, so I didn't make it for when the reporting officer was talking, so I'm not sure if there was any update there. Notwithstanding that, I will be talking to Objective 2 and Policy 2 in the noise chapter and the case for the use of the word avoid. I'll also be talking to noise Note 8, which relates to generators. And really, so I'll be talking to the maintenance and testing and planned network maintenance typically undertaken by Top Energy. I'll also be talking, Mr. Stiles is here summarising the acoustic evidence with the use of generators and maintenance and testing and planned network maintenance. And then I'll also round it out with some planning evidence on that. So that will be the largest focus of my presentation, because that's probably the largest area in contention. Finally, then I do have some comments on the earthworks provisions, and in particular Earthworks Standard 1. And also there was a matter raised in Transpower's evidence, which I picked up, which I've got a bit of an update for you on in terms of Top Energy's position and my expert opinion on their changes to that rule. So starting off first, looking at noise Objective 1 and noise P2. So as the panel will be well aware, Section 75(3)(c) of the RMA is quite clear that the PDP must give effect to the regional policy statement. And my opinion is that the wording of noise O2 and noise P2 is clearly out of step with and does not give effect to the RPS, in particular policy 5.1.1. So I've put the words in there from evidence. Essentially, it's subdivision use and development should be located, designed and built in a planned and coordinated manner, which there's an A, B, C, D that I haven't included in that. Essentially, it's a list. And this is point E, should not result in incompatible land uses in close proximity and avoids the potential for reverse sensitivity. So my emphasis added there in the underline. And that's just to highlight that and avoids the potential for reverse sensitivity is very directive. It's not qualified. it says avoid the potential for reverse sensitivity, and that's in policy 5.1.1 of the RPS.
5.1.
5.1.1 of the RPS, so 5.1.1E of the Northern Regional Policy Statement. And that's quite broad, subdivision use and development, but is relevant to the noise chapter in my opinion. The second policy which I identified in my evidence is policy 5.1.3C. So again, I've underlined, added my emphasis here, where it says at the start, avoid the adverse effects, including reverse sensitivity effects of new subdivision use and development, particularly residential development, on the following. And again, there's an A-B cut out because we're putting this on the slide. But then the relevant clause, in my opinion, here is the operation, maintenance, or upgrading of existing or planned regionally significant infrastructure. So that policy really, in my opinion, sets the context for Top Energy's submission point on noise, noise 01 and noise P2. Actually, I think I've got that reference one. I think it's noise 02 and noise P2. So just to narrow it down, the language in both of these policies provide a strong directive to avoid the potential for reverse sensitivity effects, which is policy 5.1.1, and to avoid reverse sensitivity effects on regionally significant infrastructure. That's 5.1.3. And so I talked this through at length in my evidence, but to summarise it, there was the position taken by the reporting officer with reference to Mr. Ibbotson's acoustic assessment, that essentially the avoid directive would be at odds with the proposed provisions in the noise chapter. In my opinion, that's misguided. That's not actually a test. Essentially, to put it in a way of speaking, it's the tail wagging the dog. The RPS sits up here, the proposed district plans here, which have the objectives and policies, which we have to assess. Well, we have to assess the objectives in terms of section 32, the most appropriate way to achieve the purpose of the Act. But also we have to give effect to the regional policy statement. And then once you have the objectives set, then you have your provisions which achieve those objectives. So in my opinion, it's misguided and around the wrong way to say that, well, you need to design the objective to suit the provisions, e.g. rules that you've written. That's not the test. And in my opinion, when you have a quite clear avoid directive in the regional policy statement, which the RMA says you have to give effect to, then I don't consider that the objectives set up in the PDP and supported by the reporting officer are correct. So what I put in these next two slides is my suggested wording, which aligns with Top Energy's original submission. So this is noise 02. New noise sensitive activities are designed and or located to minimise conflict. I've added the with to make the sentence work, and avoid reverse sensitivity effects on existing lawfully established noise generating activities. And you'll see in my evidence that there is actually a definition of noise generating activities in the plan, which I pulled out, so I've made it relevant to the defined terms. So the blue, aqua, turquoise, whatever colour you want to say that is, those are my additions. The other underlined words are what the reporting officer has recommended in response to other submissions, which I have no concern over, which is to add and to protect community health and wellbeing. The second limb of that evidence, based on Top Energy's submission, is policy 2. I won't read this out in full. I think what I'll do is I'll take you to clause A and B of my suggested wording, which is, again, it's outlined in my evidence attachment 1 or 2. So I've added the words lawfully established noise generating activities to clause A, and then I've added the word the need to avoid any reverse sensitivity effects on lawfully established noise generating activities within policies. Might just
Why
pause
is
there.
such an emphasis on lawfully established?
Well, the reason I recommended lawfully established is because if you have a noise generating activity which is not lawfully established and not consented, then it shouldn't apply. So I was trying to capture that part of it as well. So I thought that was helpful to say, well, if someone hasn't actually lawfully established a noisy activity, then you don't have to apply that provision. I don't have the definition of noise generating activities in my presentation, but it is included in my evidence point you towards that definition. So I have included that. I don't have. Oh, no, here we go. So it's in paragraph 3.11 on page 5 of my evidence in chief. So which is proposed to be defined in the PDP as follows: means high level of noise generated from activities that are nationally significant or regionally significant infrastructure. So it is specific to that component. And recall from earlier hearings, there is a definition of regionally significant infrastructure and regional policy statement, which flows down through to the PDP. I might just pause there to see if there's any other questions or comments on that component before I move on to the next.
No.
So this next component is noise note 8. So the noise provisions have a number of notes underneath them, which basically are the exclusions of the rules or certain rules within the noise chapter. And one of those is note 8. I don't have the wording in here, but essentially, as notified, it included a 48-hour restriction, which Top Energy sought to be deleted. That was recommended to be deleted. However, a 12-hour restriction was recommended in its place, not for emergency use, but for testing and maintenance. So within that context, what I've got here is, this is a bit of a summary of the evidence from Top Energy, and in particular Mr. Fernandez, which is in front of you. I'm going to summarise it briefly, and then if you have any questions on that component, Mr. Fernandez is here, and Mr. Williams as well online if you've got any technical questions about that evidence. But this is just a summary of that in these next couple of slides. So essentially, Top Energy utilises generators in emergency situations. So there's a storm and the network's out. Need to use emergency generators to keep power on. Maintenance and testing. So they need to, there's an imperative and health and safety reason that they need to maintain those generators as well to make sure that they can work in an emergency. But they also use them to supply electricity during planned maintenance works to minimise disruption to infrastructure, public services and consumers. So there is, as you'll appreciate from previous evidence, there is resiliency issues in the far north with the energy network. And sometimes if a critical feeder line needs to have work done on it, as I understand it, they utilise generators for that maintenance. In here, again, pulling from Mr. Fernandez's evidence, is in summary, the permanent generators are typically run for approximately 5 hours per year for scheduled maintenance, but sometimes this is longer if there is a fault or repair required. A typical total of 24 hours over 2 days every year for planned maintenance of the 110 kV line. And that's typically during the hours of 7 a.m. to 7 p.m. But again, there's always, sometimes it goes over, sometimes it's less, but that we've sort of tried to give you a conservative idea. But then also infrequent use for an additional 24 hours per year for irregular variable network maintenance activities, which are likely to occur every 2 to 3 years. So what we're highlighting there is, yes, there are numbers there, but they jump all over the place. And there's a real operational and functional need for Top Energy to utilise these generators.
Yeah. You don't mind being interrupted?
No, not at all, not at all.
Fire away.
I just had a question to the staff.
Oh, sorry.
Yeah, not to the submitter.
Go on.
Yeah. So I guess the question is why 12 hours per year?
I suppose.
Well, that's recommended by Mr. Everton at the time in his report.
All right. You might have a different response once you say the
Yeah.
evidence.
Yeah.
But if at this stage, it's because of Mr. Everton's expert advice.
Just on that question, I do address that in my evidence. So sort of highlighted it and say page 6 is where I address noise, noise note 8, and this submission, this presentation is a summary of that. But I did highlight that the reporting officer had relied on Mr. Ibbotson. But if you look at what Mr. Ibbotson had actually said in his technical report, I don't read that as a direct recommendation to include a 12-hour restriction on it. Rather, he was saying that this is typically the amount of time it's used. So I've outlined that from paragraph 3.17 to 3.19 of my evidence. And yeah, and at 3.20, I state, I consider the report officer has misinterpreted the assessment of Mr. Ibbotson. I do not read Mr. Ibbotson's assessment as a direct recommendation to change the wording of the vote. Rather, he is broadly supportive of the change to remove the 48-hour limit and expects testing and maintenance to occur over at least 12 separate occasions per year, equaling 5 hours. So I was somewhat confused by that, because when you looked at Mr. Ibbotson's written assessment, there wasn't actually a firm recommendation, in my opinion, in my interpretation of that said that he was suggesting that the rule be amended to include a 12-hour restriction. I do pick this up later on, but I think it's worth saying now. There's also a scope issue with that. Top Energy is the submitter on that point. Top Energy has requested that the 48-hour restriction be deleted, and then for council to recommend that a more stringent control comes in does seem inconsistent, because ultimately the scope of the submission was to make things more permissive, and essentially it has been used to make it more restrictive. So I do pick this up later on. We haven't got, Top Energy doesn't have legal advice on this in front of you. It was just something that I highlighted, I guess, to raise a bit of a red flag. If that was ultimately a determination to do it, I think there is an issue there if you are going to recommend a more restrictive hour control in response to a submission seeking that it's more permissive. I'll just carry on in terms of summarising this. So this total is approximately 29 hours per year, and every 2 or 3 years, the total could be 53 hours. Again, these numbers are averaged conservative, but they can jump, and the timing can jump as well. There's also use of mobile generators. So sometimes they're not fixed generators, and they typically run for 20 hours per year per site. And typically between the hours of 7 and 7 p.m. of any single generator in any single location. So daylight hours. But again, sometimes there might be exceptions to that, where it might go beyond that, daylight savings time or the like. The next note I've got there is standard maintenance and testing of generators to ensure reliable operations, also required for approximately 20 minutes every month, 30 minutes every 3 months, and 30 minutes every year. So again, it fluctuates. And it's these last 2 bullet points, I think, if you're going to take anything from the summary of that, I think are the 2 really key ones, which is that generators are very expensive to run and therefore used for the shortest duration practicable. Top Energy is not in the interest of burning diesel for the sake of it. It is expensive. It is expensive, and there's not a case of, if you have no exemption on this, that Top Energy are going to go out and use generators, because we know that they're expensive, and it's not financially or economically viable or feasible to do that.
You're not going to switch them on and run them just.
No, not for the sake of it. I think Russell will get in trouble very quickly for that. And then finally, the other point to take away from it is that generators run for maintenance during the day are very seldom run at night during planned network maintenance. So they say seldom because very rarely are they, but there might be an occasion where they have to be for some operational and functional need for them to be run at night. But what they're saying is, the use of the shortest duration possible, and then generally run through daylight hours. I'm going to pause there. So Mr. Fernandez is here, and like I said, Mr. Williams is online. If you've got any technical, I've summarised it, paraphrased it, but if you've got any technical questions, they can answer those as well.
Have you got any examples of where an emergency situation has been hindered by the rule as it is currently in the district plan? We've had to say, hey, look, we've come up to the such and such time, we've got the emergency's over now, we don't have permission to do anything any longer.
Before you provide an example, I will say that the council wording has actually accepted that emergency use is excluded. So it's not really the emergency use that we're worried about, because you have the emergency works provisions in the RMA and the way that the rule is worded by the council, but also what I've suggested in my evidence means that there's no restriction on emergency works in that rule. But I'll pass to Mr. Fernandez if there's anything you'd like to add to that in terms of an instance where that has happened in the emergency.
Not that I recollect. John, have you had any occasions where that's happened?
John with an H. Double John online.
John Williams, is it?
Yes.
Yes. I can recall one occasion approximately 10 years ago where generators were used to support the area around Taipa for a long duration from about mid-afternoon through to midnight. This was an emergency situation as the 33 kV line supplying the Taipa substation had been brought down by a tree, and extensive work was needed to remove the tree and then repair the line. That's the only significant occasion that I can recall for the last 10 years.
Okay, thanks.
Thank you very much.
Is there anything else you've got for Mr. Fernandez and Mr. Williams? I'm happy to proceed on with the presentation.
No.
I think mainly the question I had was the amount of noise generated from a generator.
Mm.
I've seen them because I've actually been to past Taipa substation. I've seen the large generators, and the actual noise generated from them, and how loud is that?
Is that a question? I'm thinking if this is a question for John with an O. Oh, John, just an O, not an H.
Mr. Stein.
Mr. Stiles, yes.
Without an H.
Yeah, without an H, there we go.
Look, they can vary quite a bit, but certainly the newer models that are also, by my experience, more reliable and more favoured by the likes of Top Energy are pretty quiet. The majority of them come factory with what they call silencer packs on them, which can reduce the noise levels by around about roughly 10 decibels, which is quite significant. And they're quite a sort of low frequency. I don't want to say it's a rumble, but it's not particularly annoying. There are no tonal components, there's no high frequency associated with it, and they tend to blend in with the background quite a bit. In terms of the actual level, the largest of the generators that I think, the mobile generators that we'd see in this instance, would be around 65 at 10 meters, give or take. So they need to be separated. Ideally, they need to be separated by at least 50 meters or more from a residential house if they're to run overnight. But they tend to be, I mean, they're used all over the place for running dewatering pumps, for all sorts of infrastructure works, and lights and all sorts of things. And they tend to be one of the least annoying sources of noise, say on a construction site or similar.
And the other question I had was the location of the generator. Are they're always at a substation, so always, within a designation? Actually,
So there's a mixture, as I understand it. So you do have fixed generator locations. The one example would be Bonnets Road, which is recently, so that's got a resource consent applied to it. You do have generators that are substations, which you have designations for, so that covers that. But then the use of other mobile generators wouldn't be covered by that as well. So you have multiple layers. Yeah.
And they're typically much smaller. I would say
Yeah.
the decibel levels should be much lower.
Yeah.
And
And look, so if you are looking at an instance of a permanent fixed generator, it's a new substation which is going to be designated, that would be considered at the time that you apply for the designation. And quite often what I've seen in Top Energy, but also I do work for North Power down in Whangarei, there are noise limits specifically in the conditions of the designation. So those ones are covered there, but then there are, what we're saying here in terms of the general rules, there are other generators that are captured, which my opinion, based on the evidence we've got from Mr. Stiles and Mr. Fernandez, is that you don't want to be necessarily having to trigger resource consents for. Okay, so this next one, again, I'll have the unenviable task of paraphrasing Mr. Stiles, so I'll do that. This is a one-slide summary of that, and I'll, like I've just done, answer any questions. So essentially, the 12-hour limit recommended by the reporting officer is relatively arbitrary and is more restrictive. That highlights what I sort of said earlier in the presentation. Top Energy would find it impractical to work to a cap of hours per year based on its typical natural historical use. So it's to say, well, if you did have this limit, how would you even be able to monitor and trigger if you tripped it or not? There'd be quite a complex regime that Top Energy would have to do that. And noting that there were also unexpected reasons as to why they might have to run for longer periods. Such a cap would require the hours on every generator be counted and tracked at all times, with all emergency use and other use not covered by the exemption to be subtracted from each generator total. So it's just highlighting this would be quite a complex calculation. The usage described by Top Energy is very occasional and temporary when compared to a permanent activity or even a construction activity. Any noise effects will be temporary and most likely limited to daytime, as we've sort of already highlighted, except in exceptional circumstances. And I think Mr. Williams has highlighted there that there was one instance 10 years ago where Taipa was run overnight. So essentially, there's a conclusion of support for an exemption by Mr. Stiles that does not limit the number of hours of use on the basis that, and he's done it on the basis of the evidence of Top Energy, which has said the use is very infrequent over the year, mostly during the day and for the purposes described in the exemption, which is the wording we've come to. So again, I'll pause there. If we've got any specific questions for Mr. Stiles or any further specific questions for Mr. Stiles, this might be a good chance to do it.
And I think that the detail that's been provided by Mr. Stiles and yourself covers up pretty much what you're saying. Yeah, thanks.
No. I think there are no questions at this stage for Mr. Stiles.
Okay. So bringing it all together, planning context. So this first point was what I mentioned earlier, which is I'm not aware of there being any scope for rising emissions for imposing a more stringent limit than the notified proposal. So I've already spoke to that. Regardless of that point, I oppose the more restrictive 12-hour limit based on the evidence of Mr. Fernandez and Mr. Stiles. I've sort of summarised it here. Generators have a critical role within Top Energy's network and are not only used for emergencies, so we know that emergencies are covered in the RMA section 330 emergency works, and also the actual wording has exempted them, but they also need to be maintained, tested, and used during critical maintenance of the electricity network. The way that the rule is drafted now will likely trigger a requirement for multiple unnecessary resource consents, which operationally would be really difficult to apply for, because how would you know when you triggered them, and obtain, and in my opinion, would have minimal overall benefit, because I cannot foresee a situation for a generator use in these circumstances that were described that would be declined. And also, it needs to be done at that point. So you're going to be applying for retrospective consents, which is already after the fact. What is if you do a section 32 on that? I cannot see how you would determine that the benefits outweigh the costs.
And how are you going to enforce it?
And how are you going to enforce it? It's totally impractical. And finally, there is a clear operational and functional need for generator use, and therefore it is important for this use to be provided for in the PDP without unnecessary time restrictions that lead to costly and inefficient resource consenting requirements. This next slide is adopted from my evidence attachment and is essentially the wording that I've recommended. So there are a couple of features that I've highlighted there. I have recommended putting this as a list just to make it work a bit better. And I've also, there was a reference to lifeline utilities or emergency services. I thought it was constructive to include a definite, to link that to what the actual definition of lifeline utilities is, which is defined in the Civil Defence Management Act. And I think I've included that within my evidence, but essentially includes Top Energy and other lifeline utilities that we would expect to see. And the exemption is threefold. So emergency purposes, I understand there's agreement between reporting officer and myself around emergency purposes. Testing and maintenance. So the testing and maintenance is where the 12-hour restriction came through in the council wording, which you can see deleted, struck through underneath that. And then finally, the additional element, which is for the ongoing supply of electricity during planned maintenance on the electricity network. So that was the third component, which we think reasonable, in my opinion, based on the evidence I've seen, reasonably covers the usage.
Can you just get confirmation all the experts that you've got here today all support provisions that you're now put?
Yes.
Yeah.
I think Mr. Stiles, it's the same as what's attached to his evidence as well.
Mr. Williams?
Yes, I agree.
Thank you very much. Thank you. Further questions?
No, it'd be nice to have a whole lot of questions for Mr. Stiles, but I don't have any, unfortunately.
Yeah, I was just thinking in terms of effects. If there was no generator, the people affected would have no power. So it's sort of like.
Yes, and look, one of the other things I would say is you still have section 16 of the RMA, the duty to avoid unreasonable noise, which applies over top of all of this, but we're trying to avoid a consenting requirement duplication.
Okay, thanks very much.
So that's the evidence on noise notate and generators. The last few points are just relating to the earthworks provisions. So here we have earthwork standard 1. So I just generally broadly agreed with the reporting officer's recommendation to structurally consolidate the earthworks rules with a single rule. Makes sense based on what's in the 42A report. But I did disagree regarding the deletion of the standard S1, which was previously referenced in Rule 7 and Rule 8. So those rules actually related to the operation, repair, maintenance of infrastructure. And what I was really highlighting there, that there seemed to be a bit of a contradiction between the position here about having an earthworks volume across the district versus in the coastal environment. So I've outlined this in my evidence, where there was no volumes proposed, was accepted that with upgrading, and I use the coastal environment, the equivalent provisions across the different natural environments. So essentially saying, well, if you're not going to have one in a more sensitive environment for the activities for infrastructure, so repair, maintenance, upgrading, then to me, it logically doesn't make sense that you would have one district-wide in terms of an earthworks volume. So what I had done there was recommend in the standard that there was an exemption for earthworks for the operation, repair, maintenance, and upgrading of existing lawfully established network utilities. And again, it's all part of a similar narrative and position had throughout the hearing process, which is to avoid unnecessary resource consents, but also acknowledging the operational and functional need of these existing assets. Again, this list does not include new assets. I accept from a planning perspective, if you've got a new asset going through somewhere, then you're going to need to look at that generally. But when you are operating, repair, doing earthworks for the operation, repair, maintenance, and upgrading of a power line, then it's got an operational functional need to be there. I don't see why it should be subject to that standard one. I'll pause there if there's any questions on that component before I move on to the last part of the presentation.
No, just to say it is helpful to have those as you've done in your evidence provided as a, like an appendix or the like, just to bring those provisions all together. That's helpful just for reviewing them. Thanks.
Yeah.
Just that word, I had just had a query about the word upgrading. That was the only query I had about it.
Yes. I'm sorry. I think Commissioner Watson was in the natural environment here. Right. So this is something I raised in that hearing because the term upgrading will pop up across all the chapters in relation to infrastructure. And there's a definition, well, Top Energy have sought a definition and particular wording, but of course we're not hearing the definitions chapter until, I'm sorry, I can't remember the updated hearing schedule, but I think it's one of the last weeks. So I agree, upgrading, if that's where you're getting at, is actually quite a key term. What is upgrading? There's a definition from Top Energy that have sought their submission, but we're not here to justify. So I think when you do get to when we do get to the definitions chapter, or if the definition of upgrading can be considered in the infrastructure hearing stream, I think it would be beneficial because how you define that is going to be fundamental to how a lot of these rules work.
I think the logic in that, if there's a logic in it, is to leave the definitions to the end because there'll be a number of changes.
Which is acceptable. Yeah, and I get that. I think if that is the case, what it will do is I think that cleanup hearing that you're going to have to then go back and look at how you define the terms and the impact that's had on the rules and how they're interpreted. But I accept out of all of those, I think operation, repair, and maintenance seem pretty well understood words. It's the term upgrading, which is the one in my opinion, you should have a clear definition of what that is.
So where did you get this definition of upgrading from?
So good question. This would be casting my mind back a couple of years. I think we've taken it from another plan in the country. Yeah, but there's a definition. So that definition is a separate one, but there's also a definition of minor upgrading in the Whangarei District Plan, which could also be an option to look at as well.
I mean, I think that's quite a key, consideration is how consistent with the Whangarei plan is what you're seeking now.
So the wording that's in Top Energy's definition is different. I don't have it in front of me, but it is different. The minor upgrading definition in the Whangarei District Plan is a lot more extensive. So the definition in the Top Energy is quite short. The minor upgrading definition in the Whangarei District Plan it's got a number of different points. But as I said, I do consulting work for North Power in the Whangarei and Kaipeka context, and that definition of minor upgrading seems to be quite effective, work well. But yeah. So if you're looking for context, that could be Top Energy's submission, or there's potentially Whangarei District Plan plus whatever council officers might come up with in the definition hearing.
I mean, I'm just thinking there's no, it's up way dealing with earthquakes, there's no scope in this here and for us to put a new definition in of upgrading. I'll recommend it. And then I suppose if we get to change later on when the definition is being dealt with as a whole, it could be tweaked, could it not? Or
Because all
amended?
the chapters aren't actually being completed, so we're just doing interim decisions that right at the end we can change any chapter.
That would be my experience as a panel would have the ability at the end of the process to go through and edit and tinker as you go. Look, what I would say is the term upgrading raised it in hearing 1, strategic direction, and then also in hearing 4, natural environments.
Have you got the word? Is it in your evidence or not?
I've got it here. Want me to?
Pardon?
Yeah.
So the requested from Top Energy, the definition of upgrade means an increase in the capacity, efficiency, or security of existing infrastructure. So I guess another option is also to tie upgrading to infrastructure, so it's not across the BDP. So that's, upgrading for infrastructure is the key issue. And I've seen multiple plans structured in different ways, whether it's the purpose or it's around scale. So I think for this rule in particular, I think what's an upgrade is just a minor upgrade versus substantial realignment of a line across the district. And that could all be part of upgrade potentially. So I agree that the definition of upgrade is important, particularly for structure.
Yeah.
So there's scope for that in terms of what we do with the submissions.
There's certainly scope to include a definition for upgrade, generally in relation to infrastructure. Certainly scope for that.
And look, constructively, Mr. Wyeth and I and others have met relating to the direction around caucusing. That's the word I'm going to use, but and I would suggest that the definition of upgrading is actually quite a key matter for that, because like I said, it's across as it relates to infrastructure. And I think you have to be careful of an unintended consequence that if you provide a definition, didn't make it specific enough to infrastructure, and you had the term upgrade used in another context somewhere else in the plan, you might want to look at how that interfered. So I guess going to a question about scope is in your hands, you're listening, hearing to the whole hearing. I'm not a lawyer, so I probably could not branch too far into it, but there's certainly the submission point on it for you to lean into if you need to. And look, I haven't turned my mind to that definition or the wording proposed by Top Energy, and I'm not suggesting it's the panacea or perfect yet, but that was just what was in the submission. It gives you broad scope.
So you've actually given us a definition for upgrading, but not part of this process today. Is that what you're saying?
So it's in Top Energy's submission. I haven't, because of the nature of the hearings process and topics that are up, I haven't given you any evidence on what I consider upgrading should mean. But it is, in my opinion, term if there was the ability for you to procedurally do it, especially with the infrastructure hearing coming up March next year, I think. Yes, March next year. That's going to be incredibly relevant. And I think there are a number of other specific infrastructure terms, not just in Top Energy's submission, but others, which would seem logical to me to try to, if you can, resolve the definitions or get some evidence on it in that hearing, because it will have consequential effects on how all the rules are administered. So upgrading is just one example, but there are other terms in Top Energy's submission and others that I've seen, which I think could be beneficially addressed at the same time.
So I mean, through this process, and maybe for the officers, I mean, are we able to ask the submitter to provide what you would see as the definition of upgrading at the present time, as a holding thing, so that we don't lose sight of where we are, rather than being referred back to, you know, other hearing sessions and what might come in a future time. So at this moment in time, for example, what does Top Energy see as the definition for upgrading that they would be seeking? Not calling for evidence, but just calling for them to put a definition on the table. Would that be out of order?
I don't think so.
Or would it confuse things more?
It may be confusing, but it gives the panel some security, I guess, in the interim. I would imagine that the issue will be quite considerably canvassed through the infrastructure chapter. Jerome?
Yeah, I guess here in this discussion, my view is that it should probably be discussed as part of the infrastructure chapter, because they're going to have change power, they have telco companies having their own views on what that definition should look like. I think just having a quick search, it generally is only views in relation to infrastructure. Good. Yeah. Okay, so
Then how do we tie back that into, we make our interim decisions on this thing when we deliberate? How do we get the definition back into here?
So
Do we get back together and then deliberate again?
Well, look, the panel is obviously a panel in its broadest sense.
Yeah.
And there will be
Wash up.
not just a wash up. I think you will have no doubt communications between yourselves around key matters, and this might be one of them that you might talk to the chair of that particular hearing stream.
Maybe in the meantime, we should maybe get Mr. Bowden to provide that, tell us where he got the definition from, and then the officer can deal with it in a reply, and maybe then it doesn't get lost. I mean, I'm not saying we'll lose it, because we probably won't, and we can mention it now, probably the decision that we had discussion about the definition, but it also then gives us the opportunity, if we decide to put it in here.
Check with AK. Who's on at this stage the chair for infrastructure? Is it?
Yeah, like it's Robert.
I wasn't sure if it was Robert.
Particularly if we're moving down a path of having separate definitions for infrastructure, upgrading the infrastructure as opposed to upgrading the other activities.
Is it me, is it? Me and
Yeah.
Wells.
Sorry, that was my recollection.
You, Ellen.
Oh, right. No. We won't forget.
So yeah,
We remember everything here.
well, yes, you'll be in the conversation, so directly in the conversation. So that,
All right.
look, and I'm sure Mr. Baden will be there in that same conversation as well.
Yes, I will. And we're going to be doing the targeted sessions subject to direction on it anyway. What I was going to suggest as a possible way forward is that you can almost put some, if the panel was of mind to support the other wording, repair maintenance, let's say, if you could put possibly some brackets around it and highlight it, or say, well, this is, subject to a suitable definition or something like that. I don't think you necessarily have to make determination now, but if you're of the mind, say, well, we think this wording is here, but we want the definition, you could look at it in that way and say, well, subject to what the defined term is. Then ultimately, infrastructure hearing, that would give parties the opportunity to present evidence on that definition, because I suggest that it is a key definition for that hearing.
and so something I was intending to address from my reply anyway, so I won't get lost.
Okay. All right. We'll leave it at that.
So I promise now.
We might have a different opinion on something.
Okay, so look, I'll move on from there. The last point to pick up in my presentations was just in reviewing the other expert evidence. There was a statement from Sharon Dines on behalf of Transpower, which related to Earthworks Rule 2. So I did address that rule in my evidence and sheet. Essentially, I said that I supported what Mr. Wyatt had done in terms of the wording, memory. But what I picked up is that Transpower had recommended some amendments to that in their evidence. And essentially, it's up on the screen there, but they'd recommend deleting the 110 kV transmission lines and also the references to 220 kV and 66 kV transmission lines. and then some other little minor changes that aren't of issue. So I had a look at that, but also just to contextualise it for you, there are definitions in the PDP relating to the national grid. So the national grid is proposed to be defined as means the assets used or owned by Transpower New Zealand Limited. So basically, Transpower owns the national grid. And then there's also a definition of national grid yard there. I won't read that one. I've got it in here for context view in the presentation. I think it's the definition of national grid that's more relevant in terms of the ownership, but I'll put both of them into the presentation. So following this, talking to Top Energy. So Top Energy is unique, well, relatively unique as an electricity distribution business, and that it actually owns and maintains some of the 110 kV transmission lines in the far north. Is it from Kaikoura? Just one, isn't it? Yeah. Did you confirm where it is?
It's Napa line as well. What is this from Kaikoura to Whangarei?
Yeah, so Kaikoura to Whangarei, obviously within the boundaries of the Far North District, but then also the Napa line, actually, which is just outside here. If you see that, that's a 110 kV line as well, which is owned and administered by Top Energy. So Transpower's wording in their evidence would be problematic for Top Energy's 110 kV lines. Essentially, those earthworks protections wouldn't apply to their lines. And just stepping back from it, looking at it from a broader perspective, or a safety perspective, is why should the restrictions apply or not apply based on who owns the line? To me, that doesn't seem like a particularly logical position, because ultimately it's a 110 kV line. The voltage is the same whether it's owned by Transpower, Top Energy, or some other entity. So also, while Top Energy doesn't currently have any 220 kV or 66 kV lines in its network, it is possible within the life cycle of the plan that a 66 kV line could be put in. The 220 kV line, talking to Top Energy, they've accepted that that's actually not something that they would likely do in the life cycle of this plan, which could be 10 to 15 years, depending on how long it takes to change, or what it's replaced with over the new legislation potentially. So we have actually, I have been having some conversations with Transpower to try and constructively find a solution on this. So pleased to say that we have, as of 10 minutes before this presentation started, there's general actual agreement on the wording that I'm going to show in the next slide. So I've been talking to them just to say, well, is there a middle ground or compromise we can come to with the wording so that it actually doesn't, still addresses Transpower's concerns, but also captures Top Energy's lines. That's one asterisk next to that is notwithstanding the reference to 66 kV lines. I understand that Transpower still might have an issue with that from a technical perspective, but they'll confirm that separately. I think they are up possibly tomorrow or Thursday in front of you in this hearing. So what I'll do is I'll send, this is been developing as of this morning, I will send this to them so they can confirm that. But generally it's just to say that there have been conversations going to try to find a compromise, and we think we've pretty much got it. So
why would you delete the 66 kV line if there's a possibility that's going to come up?
Well, that's the one, I guess, area of where there's slight disagreement. We accept that there's no 220 kV lines and it's not really possible. It's not a likelihood. You can make an argument that why don't you just leave both in, because if one is established, it's there, but Top Energy have said, well, look, we're not going to, we don't have any plans to, and that would be outside the realms of, I guess, possibilities, yeah. But a 66 kV line is within the realms of possibility. So I understand Transpower's position, and they can confirm this themselves when they come up with that. Well, why would you put a protection in for a line that doesn't exist? Was fundamentally it. Whereas the position I was coming from a planning perspective was, well, but what if one does exist in the life cycle plan? We want this protection for earthworks to apply to it. So I've sort of taken the middle ground of, well, we know that if we know that it's not in the possibilities of the 220 kV line, then but we expect that there might be 66 kV, seems like a good spot. So essentially the wording that I put forward in this slide is, now I understand, subject to Transpower confirming separately when they're up, that the intro to the rule, it's a bit small there, so I'm going to try zoom in. So previously, their suggestion was, I think it was 110 kV lines and national grid yard. So what I've proposed there is national grid, so going back to that definition of national grid, and Top Energy transmission lines, and then it's relevant only to the voltage that's in the rule. So deleted, they've recommended deleting, well, accepted their deletion of 220 kV line, but I have retained this reference to 66 kV line, just a future-proof rule. So I understand that, and there's also a couple of other changes in there just to fix the rule. Some of which are also recommended by Transpower. So essentially, there seems to be agreement on all of it, apart from this point here. And Transpower may want to talk to their position on that, but my position is, based on what Top Energy have informed me, is that it seems logical to future-proof the rule if there is a possibility of a 66 kV line going in at some point in the future. Pause there again to see if there's any questions or comments on that.
Straightforward, thank you very much.
Question for the chair, please.
Yes, you can.
So I've done something that kind of makes sense. So we've got controls for earthworks for the national grid, controls on earthworks for 110 kV lines that are not owned by Transpower, like Top Energy. But we've also got critical electricity lines in a separate sort of rule framework, which is currently in the infrastructure chapter, which should probably be in the earthworks chapter. So we've put this up. The evidence was received. So what's the kind of view of Top Energy there around, particularly the relationship between the 110 kV lines and the critical electricity lines? So what's the rule framework you'd like applying?
It's not something I've specifically looked at in terms of the infrastructure chapter in reference to the critical electricity lines. Am I right that the critical electricity lines are so 110 kV and the 33 kV network? No, and because there was an error though, I think when it was put out, because it was originally only shown as the 110 kV and then re-notified as the 33 kV. So the line, just for context, and I can shoot you back up to here. So the 110 kV line is that little fuzzy blue line running up the middle. That's essentially the spine of the network.
And that's covered.
Yeah, it would be covered by this rule. And then the purple lines are the 33 kV feeders, so the main arteries, I guess, going through. And then the red is like the 11 kV lines. Now, Top Energy, prior to the plan being notified, thought that got mapped as critical electricity lines and in there. And I just don't have in front of me. I think it is 110 and 33 kV only.
I think it's only 110 kV, but there is a submission point.
That's what I was
requesting that 33 kV be
Covered as
included,
well.
and there are further submissions on that submission point, so that's been allocated to the infrastructure chapter.
Right.
And you've got these rules for earthworks in relation to critical electricity lines, which are they basically require compliance for standard, the safe electrical standard. So that's slightly different to the national grid yard earthwork rules, but they're trying to achieve a similar outcome, I guess.
Yeah,
The national grid about 12 metres either side.
yeah, it's in that diagram.
So it's 10 metres for the.
There's 10 metres.
It's that one there.
Some differences, but potentially important for a landowner who might be affected.
Look, so notwithstanding technical position of Top Energy, from a planning perspective, I would agree that you don't want to duplicate and confuse requirements. So if it's 12 metres from the 110, but then in the critical electricity rule it's 10, I would favour trying to find a way. And so look, that's just been looking at that rule that I've been talking about, just looking at the face of it based on Transpower's amendments in the context of this chapter. I hadn't quite appreciated that there might be another overlap with it. If that's the case, I'm happy to, I don't know how we do it, but we could try to come up with a way that it's not duplicated or confused between the two, which could be done either after this or in conjunction with the Hawksend. But yeah, it's a fair point if there is overlap.
I guess from my perspective anyway, it could be useful to give Top Energy the opportunity to provide what they'd like the rule framework to look like and where it would sit, and I'd be able to address that in my reply.
Yeah.
Because I think because we are controlling the efforts of other activities more infrastructure per se, it sits better in the infrastructure. I mean, in the
Okay, so when would you, if we ask Mr. Barden to do that, when how quickly would you like that? Because I think you're delaying your right to reply on it.
Probably opportune to kind of bring
Yeah,
that.
yeah, that's, no, you don't have to deal with it now,
Yes.
but would you give Mr. Barden a week? We long enough?
Well, I guess might pay to check in how much time for a start Mr. Batten might require.
I might, just personally, because it's a long weekend coming up, I might ask a little, maybe 2 weeks if that's possible. And if you're comfortable with it. And look, what would be useful for me is to highlight the role when the critical, just, I guess, maybe if you to clarify where the overlap is.
Well, you two can have discussions.
Yeah, why don't we do that? And after
And
that,
then rather than you do something and then say, I don't like it, I mean, have a chat and then put
Yeah.
something up and then we'll give you 2 weeks to that if you're happy with that.
yeah,
You do that.
absolutely, I can do that.
We'll deal with the extension later.
Yeah.
Jim.
I'm absolutely happy with that. It might be similar to the meeting coordinate. Yeah. Yeah. Okay. So that's sort of that position for Transpower. Point. Then this is just a bit of a closing summary. So just to highlight that noise O2 and noise P2 should be, I consider they should be amended to utilise the void to give effect to the strong direction with the RPS regarding reverse sensitivity. I think for note 8, I think there's strong evidence to support that it should be amended to delete the time restriction on generator for emergency use, testing and maintenance, and use during planned maintenance, as per the wording of the report. I think there should be an exemption from Earthworks Standard 1 for earthworks, I'm said associated with infrastructure, but it's repair, maintenance, and upgrading, as I've suggested in the wording above. And then ultimately, Transpower's requested amendments will not protect Top Energy's 110 kV or potential 66 kV assets, and changes are needed to address that, and accept the conversation we just had there that I'm happy to work with Mr. White to figure out how that could be worded if it overlaps with another rule. That's it. Myself and the other experts are available for any questions if you have any.
Any more questions or are you happy as we go?
Dealt with them as we've gone.
I think the panel's happy with what we've heard and the questions were great. So thank you to you and the other 3 submitters. Thank you very much for attendance.
Okay, thank you.
We'll see you again.
I'm not up again in this hearing, so I'm out.
Do now is Waitangi at 2 o'clock.
However, they are on their way here now. I've
Oh,
asked
okay.
them to come here early.
That's great. That's great.
Nicole was obviously coming from Waitangi, so she'll be a while. So
What we'll
maybe
do now is deal with the extension if you want.
Can we get one, Mr. Chair?
Oh, yeah.
Excellent. Job done. No, Mr. Chair, obviously, it is, there's I guess a few things happening. Obviously, there is a long weekend, but also we've got some tight turnarounds coming around in the next sort of month or 2. So we were indicatively thinking maybe 20 working days in this instance as opposed to it's going to be 10. We may touch base if there's an issue, but there's quite substantial works coming at you through the pipeline in the next little while, rural chapters, and so it's just quite substantial work. So we need to get those online in the next few weeks. So those are probably our priority as well. They are quite substantial chunky pieces of work. So 20 working days probably certainly be helpful.
Well, we've got no problem with extension for the report from some fine. Mr. Wyatt needs an extension because of the communications with the
I think
pattern.
that'll be fine.
If not, we'll get it in 20 working days.
Thank you.
And if there's something goes wrong or you need an extension, come back to us early and then we can consider it as a panel.
Ideally not, Mr. Chair. I think
Thank you, Mr. Madam.
where we can, we might be able to get individual topics back to you earlier, if possible. They actually are, some of these are quite technical topics. I'm thinking noise networks, so those might not be the first ones off the rank, but there may be others that might be able to get responses to you again.
All right, okay. Otherwise, what we'll do, take it in German, will we?
yeah, we'll
Unless
just
you
take
get
an
anything-
adjournment until I get confirmation. We're hoping maybe 11:45, which is 15 minutes.
So when we come back, we're going to deal with Waitangi in a minute.
Yes.
And then what about, the chorus for Chris Vaughan?
He will be available at 1 if we want him to be.
All right. Leave him at the moment. We'll see how we go
Yeah.
with Waitangi.
Yeah.
Okay, thank you.
Okay. I will get the room just.